Everybody. Thank you, all of us who tuned in for this special edition with our special guest, attorney Brent Renison, on a Friday evening. And we sincerely appreciate your time. And we apologize for a delay about 15 minutes to start. There was a little glitch in Facebook. We were unable to do that. We sincerely apologize for that.
No problem.
First of all, our thoughts and prayers to President and our First Lady. We are wishing them for a faster recovery. And also, we will be praying for Senator Mike Lee for his recovery and for this deadly COVID disease. We really want it to go like yesterday. Friends, I would also want to share that it's been a year that since Immigration Forum was started. And as all of you know, it was certainly been an incredible and incredibly challenging and yet fulfilling journey. We are thankful to the community who continue to support us and the lawmakers who graciously engaged with us. We are particularly thankful to the staff of Senator Mike Lee, the primary sponsor for S386, and also the staff of Senator Durbin for patiently engaging with us in meeting after meeting. Most of the people only heard from second-hand sources so far. So I take this opportunity to say that I am very proud of Immigration Forum team and supporters who place their trust in us. And as we engaged with the conversation with Senator Durbin over many, many months, we started off with explaining the situation of the community, asking for support, and eventually Senator Durbin supported for S386. Being able to do this for our community is very humbling, and we are very happy about that. Many of you already know this is just not the support of one senator. He's the top Democrat in Immigration Committee and commands huge respect of time and his credentials. Please be assured that we are continuing our efforts and will keep as it till discrimination is removed. And let me move on to our special guest. Hi, Brent. Thank you on behalf of the entire backlog community for consistently and vocally supporting for S386 and also for litigating in support of aging out kids. That actually means a lot for thousands of people. We sincerely appreciate you. Now, elimination of country cap remains to be the primary goal of Immigration Forum. Could you please compare the advantages of passing S386 with the opportunity of adjustment of status we have due to spillover, which is the need of the hour right now?
Yeah, well, thank you for inviting me here, and I appreciate you for your organization and what you do, and it means a lot to a lot of people. Thank you. Obviously, we need immigration reform. We can't just rely on extra numbers sometimes. This is an unprecedented situation because of the immigrant visa ban. A lot of family-based immigrants who have waited for decades as well are not being reunited this year. And it's because of that situation that these new numbers are coming available to employment-based numbers. And it's just a terrible situation. Unfortunately, the Republicans have continued to block efforts to increase the overall numbers. And we'd all like to see more immigrant numbers. We don't have enough immigrant numbers for the size of country that we are. But anyway, I can talk about policy all day, and it's not going to really help you in your cases. But in this situation, obviously passing Senate Bill 386 would be an amazing achievement. It's probably not going to happen unless it gets on an appropriations bill at the end of the year. It'll die, and we'll have to start over again with some new bill. The provisions, the provision would eventually get rid of the backlog over a period of years. It wouldn't be fast enough for some people. Durbin tried to get an age out provision for kids in there. It was refused by Senator Mike Lee. I don't know why. Maybe it couldn't fly with, his other colleagues on the Republican side. Whatever the case is, it just really, it's still stuck. So I think the important thing is that, yes, advocacy is still needed, absolutely, until this national origin discrimination is over. But for now, at least this temporary situation will allow a lot of people to at least file for adjustment of status. Filing for adjustment of status gives a lot of benefits, even if there's some other problems that I'll talk about, during this program.
All right. Thank you, Brent, for clarifying that. Now, there is one enactment date situation, right? Because it's past October 1st, and anytime the ST86 gets signed, it will only be enacted on October of 2023, which is 3 years from now, that we can see any movement or any benefits out of ST86. So is that a correct understanding? Because we keep hearing multiple variations of the answers, but we would like to hear from our dear attorney.
Well, as far as the effective date of the act, it's supposed to be, and here's the thing is we don't know what the provisions are going to be. So I'm just looking at various drafts, and these drafts can change. In fact, they can change real time as things are negotiated last minute. People throw in provisions. So, so it would be changing, the changes to the most recent version. It would be effective with 1 year from the date of enactment. And then there's basically a transition period that would make it the first day of the second fiscal year, beginning after the date of enactment. So that's a long way off for it to even start. And then there's a phase-in period over 9 years, slowly increasing the numbers. This is to protect the, people who have it good right now. It's the real situation. And so it's it's something. It's not the greatest thing we could get. The greatest thing we could get would be what the Democrats have continually tried to get past, the Relief Act, and hasn't been able to go forward. So it's better than nothing, but it's not going to help people for a long time. So we need to see what we can do now. And what we can do now is some people can downgrade to EB3 and file adjustment of status. And then what does that mean? And what does that mean for their families?
Thank you. Thanks for that, Brent. Yes, and we would definitely continue our advocacy till any such action gets and the discrimination will end. We would fight for it till that happens. Now, moving on to your very dear subject, the Child Status Protection Act, CSPA. So how, I would assume Ranjit, who is our wonderful host, would actually drill in more, but at a highest level, would you give us to a layman, how does these two impact our the children who are aging out when coming to a final action date or a final date in the chart that USCIS has published?
Yeah. Well, prior to the Child Status Protection Act, if someone turned 21 before they actually got approved for the green card, they would be ineligible and denied. So that was, we used to have to file these rush applications, file 2 months before the person's going to age out and rush them through. Well, this provision, it helps some people, but not everybody. And Child Status Protection Act is basically allows you to add to your 21st birthday some days. And the days are the petition that's being used to file adjustment of status or to get an immigrant visa. You add those days that the immigrant visa was pending to your age. So if you're age 21 today, but your petition was pending for 3 months, you don't become 21 for 3 more months. That's the first provision. And some people are confused about priority date versus the petition dates. The priority date is often it's going to be the labor cert date for any EB2 or 3, unless it's national interest waiver. And so, but you don't look at that priority date in figuring out the CISPA calculation. The actual person's age is only modified by the dates between the receipt date on the I-140. So it's called the received date. And then the notice date is actually the date of approval. You don't count that particular day of the notice because it was approved that day. It's not pending. So you just count the number of days between the receipt of the I-140 and the approval. And so if you've had a premium processed I-140, you might only have it pending a few days, and that's not going to give you much benefit. But if it got an RFE and then, gone through all kinds of like delay, that's actually better for your children. And so, you have to look at that calculation. Okay, so that's number one. How old are you? Okay, that's your age. CISPA age is your actual 21st birthday plus the days of the I-140 pending. Which I-140? Well, it's the I-140 you're going to use to adjust status. And that's confusing because some people are going to file with EB3 now, and they have an EB2 petition. Well, if they later move to the EB2 petition, they have to do the calculation before they ask to move to the EB2 because the calculation might be not beneficial to their kids. So, and I'll explain that a little bit more, but essentially, I mean, you have the situation right now, which is pretty confusing because since 2015, they created 2 charts instead of just 1 chart. And to confuse the matter even more. And it makes us laugh, but it's really a terrible situation because we have one plaintiff who's going to represent all of the people who are now going to be affected by this. Like, what happens is you file your adjustment of status and your child is, let's say they're 21 right now, but you have 3 months on your I-140 pending. Okay, file the adjustment now because the priority date is current. But which priority date? It's the dates for filing priority date. That allows you to file adjustment of status, but it doesn't lock your age. Only the dates for filing being current, meaning your date is earlier than the visa bulletin date for the final action date. Only when the first day of the final action date comes current, so October 1, November 1, whatever it is, if your child is still under 21 based on their CISPA calculated age, then you can lock it, okay? So only then. So EB2 is still in 2009, EB3 is 2010. I mean, lots of people are going to be filing with priority dates all the way through January 2015. Lots of people are going to be filing adjustment of status, and they need to know that their children who are eligible to file adjustment might be denied adjustment later if the final action dates don't move forward fast enough to catch up before they're 21, before their CISPA 21 age, okay? And the other thing is, one more thing is, it's not as relevant right now, but there is a rule that says if you are still under 21 for CISPA and your date comes current, you have to file within 1 year of it becoming current, but that you only have to file within 1 year of the final action date. So that's not really a problem for most of the people now. And there's some complicated things, but I don't really want to talk about the 1 year sought to acquire thing because it's not a big issue right now for most people. What is really an issue is final action date versus the dates for filing. Now our lawsuit challenging, I can talk about that a little bit. Maybe I should pause for any questions about that. But I mean, the lawsuit does challenge the use of final action date versus dates for filing. We think they should use the dates for filing to lock the age, not the final action date.
Thank you. I mean, that explained that is explained very well, and many of us who are listening and tuning in would definitely got benefited with the CSPO calculation. We appreciate that. Now, I also take this opportunity to welcome you to the show and welcome Ranjit. So over to you, both of you. Have a good one. Thank you, guys.
Hi, Brent. Welcome to the show. Good evening, everyone. Welcome to the live show brought to you by Immigration Forum. My name is Ranjit. We are here today with the prominent attorney, Brent Renison, to discuss latest updates on Visa Bulletin, CSPA and CSPA calculations, and frequently asked questions. You can call in the numbers displayed on the Facebook page to ask a question. We'll start taking calls in about 15-20 minutes. Before starting, I would like to thank you, Brent, for all that you have been doing. You have been vocal about S386. You have been vocal about removing the country cap, national discrimination. We really appreciate what you have been doing. I know it's not a small thing. You have to take own time, especially you are doing pro bono on CSPA and a lot of other stuff, which a lot of attorneys in America doesn't do. When you are communicating, especially with a client, you have to have empathy towards the client, and we really appreciate you understanding the problems and helping out, especially the kids who are suffering and whose life already they've been already here from quite some time. Before starting, I would just like to ask you to give a small intro about you, and then we can start with the questions.
Oh, sure. I've been practicing immigration law since 1997, and prior to going to law school at University of Hawaii, I worked as an examiner for the passport agency for the State Department for a number of years, and issued passports and adjudicated citizenship claims, and I spent time in China and Taiwan, and I speak Mandarin Chinese, and that's kind of my background. I live in Oregon, and we now no more we don't have any more wildfire smoke, so I'm glad about that.
Thanks, Ben. Thanks for being so humble. Okay, let's start with your forte, which is CSPA. I know you have been advocating a lot on CSPA. A lot of people now have questions: is I-485 filed under current filing dates will not freeze the child's age under the CSPA if the kids are aging out? I know you have a lawsuit going on about it, but before that, I just want the viewers to get a clarification that filing dates will not freeze the child's age. Could you please throw some light on that?
Sure. So filing, right? If you look at the dates for filing, and your priority date is current, and you can file your adjustment of status in a given month, let's say October, because the dates moved forward crazy fast. You need to look at your child's CISPA 21st birthday. So the CISPA 21st birthday is basically, like I said before, it's you take the 21st birthday of the child, and then you add the dates that the petition that you're using were pending. Now, if you're filing an EB3 downgrade concurrently, and your child their actual age is under 21, not the calculated age, but the actual age is under 21, well, you can, as many days as your EB3 downgrade petition are pending, they're like basically extending their 21st birthday, right? So whatever petition you use to adjust status ultimately will determine the child's eligibility. So you gotta figure out what your child's actual 21st birthday is, add the number of I-140 petition pending days between the receipt notice and the notice date, not priority date, but the receipt notice and the notice date difference. Add the number of days, and that's the 21st birthday for CISPA. So CISPA 21 age has to come current in order to file adjustment. You have to be under 21 to file adjustment. If you're filing adjustment and your child's under 21, you can file, but in order to have the age completely locked in place and not keep increasing toward the actual CISPA age, right? You actually need to have your priority date come current on the final action date. That's according to USCIS. So right now, if your EB2 2014 priority date, you can file adjustment of status, but 2010 is the cutoff date for final action. Is it going to advance 4 years? I don't know. But if your child is very close to their 21st birthday or they're 19 or 20, that's going to be possible age out while your adjustment is pending. So we don't think that's fair. We think as soon as the dates for filing comes current, your child's age should be locked, right? I think that's, everybody agrees
Makes sense.
be the way to go. But USCIS has not done that. And so they're doing this crazy thing where they're making people eligible to file and then taking it away later. It's totally unfair. So our lawsuit has one of the plaintiffs who has this situation, and she is representing all of you to be able to have this claim. And if we win the lawsuit and it's a class action lawsuit, if the class is certified, then all those cases should follow whatever ruling we get from the court. And I'm hoping the ruling is no, USCIS, you cannot make people only freeze their age by dates, the final action date, but you have to use the dates for filing. The other part of the lawsuit is more involved. It's based on nationality discrimination. We believe that everybody should have their children's age locked as of the date that everybody else gets to lock their child's age. So this would be other countries, the other countries chart.
Oh, okay.
That means, so that if we win that claim, that's a national origin discrimination, then, you know, your 19-year-old probably got their date locked back when they were 13 years old, you know? So that would be a big win for that claim. So we have two claims. One is the national origin discrimination, trying to get them to allow us to use the other countries' visa bulletin for locking age. And then the other one is, you know, is as I stated, the dates for filing versus final action date.
Okay, the second lawsuit you were talking about, the locking in the age based on the other country's final action dates, right? So let's say one of the countries has a final action date as a current. That means, you know, all the people in the world get to freeze their age, right?
Yeah, if the final action date is current when you file your I-140, then your age is locked.
Oh, so
so that would, you know, that would help a lot of people. So we're hoping that will win. That's, as I've spoken to many people about it, our two claims. So we have one lawsuit with two claims. Okay.
Okay, got it.
And so there are some people who don't have the dates for filing versus final action date issued because they already aged out before their final action date came current. Okay. Those people are going to need to have our help with the national origin discrimination claim, where we want to have the ability to use the other countries chart, not the discriminatory India-based chart. We want to be able to use the all other countries chart to lock the age. Yeah.
So,
and then the other one, that now suddenly there's going to be a lot of people who file adjustment based on final action, but they're going to age out by the time the final action date comes current, and they're going to need us to win on the other claim too. So obviously, if we win the national origin discrimination, that's better than the other one.
True.
We win that, then we win everything. If we only win the final action date thing, that'll help some people. That'll help the people who are, you know, filing now.
The second lawsuit, which you said, you know, national origin discrimination, will it be applied retroactively to the people who, you know, let's say whose petitions are already pending, or it only applies?
Yeah. So basically, there's as long as the lawsuit should go back in time, a long time, for anybody who aged out, even in many, you know, years in the past. It should go back. It should be retroactive. So the only thing is that we have to win.
I know. How long would it take? You know, do you have any timeline? You know, what all factors are dependent on it?
So in a lawsuit, the government gets to file to have our case thrown out. It's called a motion to dismiss. They already filed that, and it's before the court. We already had oral argument in August. And so the judge said that she needed significant time to review all the issues. And it's going to take a while for us to get a decision on that. Okay. Then once we're allowed to proceed and the judge says, no, I'm not going to throw out the lawsuit because of jurisdiction or the other things, then we get to file our motion for class certification to get the case, you know, certified as a class action, so that not only does our lawsuit affect just the plaintiffs, but everybody with the same situation. And some class actions require you to register. This is not that kind of one. It just means if we win, even if you never contacted me, but if you hear about the lawsuit and, you know, it would affect you positively if we win. Now, that class certification motion and then the final judgment after that is going to be next year, probably. Okay, so it's going to take some time. And then even if we win, or let's say we lose or win, either side can file an appeal to the US Ninth Circuit Court of Appeals, and that could take a year or two more than that. So I'm really not sure, and it depends on the next administration. If it's if it's a Biden administration, they might be willing to like let the judgment stand and not appeal a positive judgment. Maybe they would, you know, or maybe there's some legislation, maybe some bill is passed that makes our lawsuit, you know, not relevant anymore. But, you know, the other thing is a lot of legislation is not retroactive, a lot.
Yeah, I know.
And so even if we do get some positive change with Senate Bill 386 or whatever the next one is, I think our lawsuit will still be relevant because there are going to be people left behind who already aged out.
True.
Yeah, so I think it's still going to be relevant. So I'm going to be continuing to work hard on it, and hopefully we'll win it.
Okay, coming to the next question. Now it has become a trend to downgrade. So a lot of people are filing downgrades now, EB2 to EB3. So you mean to say, let's say EB3 filed concurrently, obviously will not be approved anytime sooner. Let's say if it's pending for a year, that means child gets protection until the age of 22 because it's pending for a year. So 21 plus 1 will be 22 years. So they will be protected until 22, right?
Yes, that's true. That's true if you have two petitions. So if you're just EB3 only, that's you rely on that petition, and it's not complicated because it's the number of days it was pending.
Yes.
See all these downgrades now. We don't know how long the I-130s are going to be pending. Also, think about it. In a year from now, are you sure that EB3 is going to be better than EB2? It might not be. The action date might not be better. So you might be tempted to say, all right, I filed my adjustment together with a concurrent EB3 downgrade. And now I'm a year into my adjustment of status. My child is starting to get close to 21. I'm seeing the dates go the other way. Now, EB2 is in 2011, final action date. I mean, it could happen.
Yeah.
And then EB3 is still stuck in 2010 because everybody filed to downgrade. Well, it could be that then you have to ask the agency to switch over, which, you know, when your adjustment is pending, you send in a letter, you say,
interfile.
You interfile a request and say, I want my case considered under EB2. And then they switch it over, and then they count the days that petition was pending for the CISPA analysis, not the best one. And somebody had a question, can I just add up all the days all my I-140s were pending? And you cannot. Also, you cannot use the most favorable I-140 pending time if you're adjusting another one. So it's going to be extremely complex. And I think USCIS might be in for a real adjudication nightmare as they start seeing these families' cases. And they're like, oh, well, which one should I use? This one's current, but if I approve them under this, the kid gets denied. And on this one, if I do it under EB3, you know, they are not current, and then should I wait? It's going to be crazy. And it's crazy because they created dumb situation themselves by only locking the age at final action date. If somebody files adjustment of status based on a current priority date, their date should be locked.
True.
Completely ridiculous. And
that's even practically
we will win in court, but it's just going to take some time to win it. And hopefully, you know, maybe they would change their mind once they start seeing all these weird cases with the two petitions.
Yeah, I know.
And 3, each EB2 and 3 has a different pending time, and has a different CISPA calculation date, and it's just going to be complex. And in my mind,
yeah, true. And especially now, I believe, I mean, at least maybe 100,000 or more applications are going to be filed, and it's really a nightmare for USCIS, because as you said, it's going to be tough for them to compare all the I-140s, then, you know, which one to take, which one not to take. That's going to be a messy situation. True. And another question, let's say, you know, someone filed in the filing dates, and, you know, their I-485 is pending for quite some time. And before the kids age out, let's say few months before the kids are aging out, the dates become current. So will the kids be protected then, because the final action dates become current? How do USCIS know?
Well, so what happens is when the final actions date finally comes current, they look at the case again, and they've maybe cleared all the things they need to, ask for the medicals, they've done the records checks, and then they're going to adjudicate, you know, the case. If somebody's locked their age, so an age will become locked in, and it will, like, you become ageless at that point.
But how do USCIS know with hundreds of thousands of applications?
Only if the final action date comes current before your child's CISPA age 21.
Yep.
And if you're on the first day of the month that the visa bulletin says final action date is after your priority date, and now your priority date is 1 day or more earlier than that, on the first day of the month, your child just stops aging.
Yeah, but how does USCIS know about it? How do they keep track of it with thousands of applications? And
well, see, it probably was easier when they just had one visa bulletin.
Yeah,
it was just one date to consider, right?
Yeah,
because then they never had anybody where they would file adjustment of status. Because if your date's current, for you to be able to file your application, and there's only one chart, well, then when you file, it's locked.
Yeah, true.
But when they created the two filing, you know, the 2 chart thing, it just created a madness. And so I don't know. One of our plaintiffs has, you know, has her case she aged out almost a year ago while pending adjustment. And we're waiting to see what will happen, because now the priority date is current for the final action, but she didn't have her date locked. So we don't know. They have told us in sort of the court filings that they will evaluate the CISPA thing when the final action date comes current. That's what they've told us.
A lot of redundancy here, you know, a lot of confusion. But, you know, recent times USCIS have been doing a lot of mistakes. Even they are sending out correct checks. They are sending out correct forms being written. You know, no one knows now if they are going to handle these cases properly, especially with bulk number of cases being filed. You never know what will happen. So that's kind of very scary for people, especially who are about to age out.
Mhm. Well, I think some techniques you can use is first of all to know that if you are EB2 and EB3 eligible, meaning your current employer, current job, or like some people have said, like, oh, can I move back to my old employer? Because that's the petition. Yeah, sure. If you have an offer of employment from your I-140 employer, whether it's your current employer or a previous employer or even a future employer, and you have the option of EB2 and 3, well, you should have both of them. You can have both of them. The attorney just needs to make sure to not check the
Amendment
2 question that says, am I amending the petition? No, you're not amending the EB3. You just leave that blank. And then page 3, question number 9 and 10 deals with if you are filing based on a labor cert that's on another I-140. So you check, yeah, it's on that one. And I'm trying to get my old priority date, same perm labor certification, and then they should approve you. So you should have 2 I-140s, and you're hoping that maybe, they're all pending a long time. There's a lot of complex questions that people have about it because, do I lose my EB2 if I filed EB3 downgrade? No, as long as it's not amended petition, it's an additional petition. Can I, if I file adjustment on EB3 and I get an EAD and then I upgrade to EB2, do I lose my EAD? No, you don't. The EAD is based on adjustment of status. There's been questions like what happens if the priority dates come better for EB2? Should I upgrade? Well, sure. It's just not always that fast or automatic, because then you're trying to correspond with the agency when you have no form to file. You're just sending a letter to them, and do they receive it? Because you don't know. There's lots of tricky questions.
Yeah. However, now as you said, it has become a trend of EB2 to EB3. Do you see any challenges or risk in EB2 to EB3? Because a lot of people have those questions in mind. Do you have to wait or do you have to file?
Well, okay. So obviously, if we knew what was going to happen next month, it would be great, because then maybe if they were more reasonable and they just kept the EB2 and 3 dates the same, they would get the filings that they wanted. I mean, they moved forward EB3 so much to what's called spur demand. They want a bunch of applications pending now, so that they have enough to adjudicate, so that they can issue all the visas they need in this year. Okay, so, but once they get a whole bunch of applications, like you said, they're going to change the dates. They're going to retrogress them. And I would say, if you're able to file adjustment of status based on a different category, you should probably, of course, every case is different. Get advice from your lawyer in an independent case, because there could be some weird thing with your case that, is not. So I can't just say, yeah.
Yeah, especially I think the Schedule A physicians and therapists, they cannot, downgrade because they don't have POM.
Yeah, well, it's a different, right? It's a different, you would file a different petition with a different category. Now, Schedule A Group 2 extraordinary ability is just EB2. And unless you have, certain, unusual case, you're basically, you're either EB2 or EB3. But for all the perm labor certification based ones, they're just, if you qualify for EB2, you would qualify also for EB3. Yeah, so,
yeah, true. So the other thing, a lot of people, again, have a dilemma about this EB2 to EB3. Is there any regulation that in USCIS that says EB2 to EB3 is possible, or we don't have anything such, and it's a gray area because of hundreds of thousands of applications now?
No,
What if
no,
USCIS denies?
no, you can file a petition. You can file multiple petitions for the same labor certification. That's clear, based on different category, EB2 or EB3. That's clear. You can also file an adjustment of status application on any petition. That's a valid petition, whether it's EB2 or 3. Doesn't matter if you also have an EB2. You could file for EB3 adjustment of status. And so adjustment of status gives you certain benefits like an EAD for you and your family, an advanced parole. It also allows you to potentially get into the area of the 204J portability, where what that is if you have your adjustment of status pending for 180 days, if your adjustment of status is pending for 180 days, then if you move jobs, either jobs within the same company or a different job with a different employer, then if that new job is same or similar, and that's a legal determination to make, is it same or similar? But if it's a same or similar job, then you could move to a new job after 180 days and keep your I-140 valid for the new job. So we file lots of cases where, pending 485 for, 6, 7 months, 8 months, a year. And then, hey, I have an offer to go to Texas and you're in Illinois. Okay, normally you couldn't do that because the perm is location specific, but if you have a new job offer in Texas, well, okay, now you can take that job. And then we file an I-485J supplement with explaining the two jobs and explaining how they are similar. And there is a memo on this, and it's a very complex memo. It's not common sense what is same or similar, okay? But if it's a same or similar job, then it could be, you could move to the new job. So there is benefit to having 485. Also, let's say we win our lawsuit and they have to use the dates for filing. Well, then you get your age locked at dates for filing. So that's maybe another benefit. I don't know, but generally speaking, it's better to be a pending adjustment applicant than not.
True.
Yeah.
So, so you would say that it's worth trying in EB2 to EB3, and chances are pretty much it will get approved unless there are weird scenarios. As you said, always there are, exceptions, but then most of the times it is feasible.
Yeah, it is. And, yeah, it's feasible. And again, people with kids would want to consider not filing premium.
True. Yeah, that's a good idea, actually. Yeah, at least they can lock out their age. I mean, they can extend their age for a certain period.
Mm-hmm. And I've had lots of people explain with all their I-140s, I've got this I-1, and that's the other thing is how do we know how many people are really pending, like out there in the backlog? Because they're counting every I-140 as one family.
Yeah, true. Yeah, depends on.
Family has like 4, 5, 6 of these I-140s out there.
True. Sometimes, yeah, and even sometimes family members. That's probably one of the reasons why retrogression happens, right? When they calculate, they only calculate principal, and sometimes family members end up adding to it, and then 3 or 4 people are being used by only one family.
Mm-hmm. Well, and there with a new administration, let's say, who's creative thinking, they could simply say that at the beginning of the fiscal year, every priority date is available, and they could just make current the whole list and just let everybody file and then lock in everybody's ages. But they haven't. But some new administration might be able to do that. So who knows? There could be, I'm saying you all need to, push for legislative change for sure.
True.
But there's also ways that an administration can be creative with the law, and the courts allow the agency a lot of leeway to determine their own, matters. And so they could do something positive like that. That would be amazing. I think you should be pressing any new administration to immediately consider moving all priority dates current for a couple of, 3-4 months, so that everybody could file adjustment of status and lock their age, and then they work through the numbers.
Wish it was, that immigrant friendly. Let's see, let's hope everything changes and some immigration reform happens, and, wish the immigration doesn't get so complicated. We'll start take questions, and, before that, I would like to repeat the disclaimer for all the viewers. Please note, this show does not provide any legal advice. It is general in nature, and it is only for informational purposes. Things change, on case-by-case basis, so please use the information at your own risk. We are not responsible in any way for your actions. Let's start taking the calls. The first caller is going to be Bhaskar, number ending 8154. Bhaskar, number ending 8154. You are on the air. Please ask your question.
Hi, good evening. This is Bhaskar. Hey, I have a couple of questions. Yeah, primarily on that CSPA. I have a 16-year-old, and my priority date is 2011 June. So I'm wondering, is this a good idea to file 485 for my kid, or wait until his final action date becomes current? Because what I heard is, if I file 485 down the line, if final action date, let's say, never comes out and the child ages out, then it's very difficult to get an F1 visa for him. So that's my first question.
Yeah, that's tricky, because F1 is a visa type that requires you to have no intent to abandon your foreign residence. And, certainly, if for people who are trying to maintain their non-immigrant status, if, for example, they were trying to change from H4 to F1, if they fully disclose their situation, that they are, they have the, an immigrant petition filed on their behalf, et cetera, that they are a derivative beneficiary of that. And if it is true that, were they required to go home, they would, then you can put that in an F1 application and be truthful, and it still can be granted. But it certainly is a difficult situation to be in. I understand, and I would not like to be in your situation, because it's difficult. You're very close to the dates for filing for EB2, and yet you could give your and your family.
Yeah, I'm also planning to downgrade to an EB3, so that one thing is, as you mentioned, that 140. My previous 140 was approved in 2 months, so maybe this one will probably take longer time, and then give me more time for my kid to age out.
Well, yes and no, because your child is 16. They have 5 years to be 21 plus whatever the time is, and you have a chance to file a downgrade I-130. I'm 40 to EB3. You should do that for sure if you're offered the opportunity. Absolutely do the downgrade EB3. And just let me take a moment to say it's a misnomer. It's probably not a good word to say downgrade, because you're actually not downgrading the actual EB2 petition. You're doing an addition. Right. So somebody should come up with a better word than downgrade. It's unfortunate, but it's basically an extra petition. So you do an extra I-140 in the EB3, and then you do it regular and hope it pens a long time, giving extra time. But see, even if you do that, if the EB2 dates get better than the EB3 dates, then maybe the 2 months is better than a year of EB3 pending I-140, you see? Because if they come faster, C would be better. So, but by filing another I-140, you give yourself and your family another option And then the other question is, should you file adjustment of status? Well, I don't think there's necessarily a downside that I can really think of for most people to not file the adjustment of status, because you could downgrade now, do a downgrade petition, file adjustment of status. I guess the only thing is you're thinking about later an F1, right? So that's the only possible, downside. And
let's hope things change in the coming 5 years. And 5 years is a lot of time, Brent, I believe. And
yeah, but you see, the problem is I have clients who were pending for many years on a May 2009 priority date. Many years.
I know.
It's just stuck for many years in 2009. Now, the question is, I mean, you're very close to the cutoff date to file EB2. The question is, would you file adjustment of status if the EB2 date was current? I think you would, probably.
Let's hope things change. The next caller is Kiran, number ending 9704.
Yes.
Yeah, please go ahead. You are on the air.
Thank you, Brent. Actually, I have a question regarding Schedule A worker. I'm a Schedule A worker physical therapist, and I have EB2 petition approved from 2011 June. And so my question is, to downgrade, do I need a labor condition approved again, or the old one can be used? And to file a new petition, like a downgrade, that you're not saying this is an additional I-140 if I move to EB3, then should I do that or do an amendment? I know you said not to do amendment, because if we do amendment, then I cannot use and the EB2 approved EB2. So what would be the safer one? Is the amendment would be safer, or the filing a new EB2, EB3, if it is possible, with old labor condition, because we do not have a form.
Well, I think some other immigration attorney out there has the answer, but not me, because unfortunately, I haven't had this particular Schedule A thing come up for me personally and thought about it in this way. So I can't answer your question, and I'm sorry.
Actually, the same question was yesterday probably answered. You can probably take a look at the live session that we have done with Tiffany. Tiffany has answered the same question. And I believe she said when you don't have a labor cert, there is the possibility of the downgrade or whatever you call another petition is not possible. But then to make sure, please take a look at the session. It's recorded on the Facebook, and you can see it on the page.
Yeah, so you can see that on that page. But the basic situation is you can always retain your priority date for a new filing. I just don't know for the Schedule A case whether you have to, for example, obtain a new prevailing wage determination that's valid for that new I-140. Also, I'm not clear myself whether, in what circumstances a Schedule A worker can be EB3, for example. I think you should be able to be, but it depends.
I think Tiffany told that, they come under EB2 professionals and there is no possibility of EB3 for them, something like that. But then if you have time sometime, if you can take a look at it and post on Twitter, it would be helpful for everyone.
Sure. And that doesn't, it doesn't preclude. Yeah. Okay. So I'm going to pass on that one.
Yeah. The next question, number ending 6486,
Yeah. Hi, this is Tirupati. Thanks, Brent, for being available. So this is similar to the first caller with 16 years kid. So I have a 17 years old kid with July 2011 EB2, okay, priority date. So the question what I have is, let's say come next bulletin, which might release around October 20th, if my date becomes current in EB2, can I go ahead and file in EB2 and also at the same time file just 140 in EB3. So that way, my 140 will be in progress, hopefully for longer time. And in the event that EB3 date becomes current, the final action, I can switch over. That way, I can have both options instead of directly downgrading to EB3. So that is one. And the second question is
Yes,
to calculate the age. Okay. Please go ahead.
Question?
Yeah, the next question is to calculate CSPA, that age, you were explaining. Do we need to file 485 for the kid, or it doesn't need to be at this moment? So, yeah, that's typically the second question.
Okay, so the first question was yes, because you could do the reverse. You could file your adjustment on your existing EB2 petition if you want, if that's current for final action date. I'm sorry, for dates for filing. And on the side, you can do an additional I-140 and EB3. In fact, many people are in the habit of filing, as soon as they get the perm certified, you file two I-140s, one in EB3, one in EB2, same time. They might be pending different times, but they'll both get approved. Okay, so you can always have that, and that's a good technique to, another option for you. Yes. And then the second part of your question was how you should, should you file an adjustment of status for your child? Well, first of all, if you're filing adjustment of status, you better file for your child, because if you get approved and they don't, they're not legally, able to stay on an H4 anymore, right? So they're going to file with you together. Unless they have like some other status that you want them to be on for a while or something, and they can follow to join you later by filing later. But essentially, the rule says for CISPA, if you want to be eligible for the CISPA benefit, you have to file your adjustment of status within 1 year of the final action date coming current. So that's the rule at the moment.
Sounds good. So the next caller is Sri, number ending 4133, number ending 4133, Siri.
Yes, yeah. Hi,
please go ahead.
My question is, hi, Brent. Yeah, hi, Brent. My question is, my priority date is July 2012, okay, under EB2 category. So if I downgrade to EB3 and if I use EAD or advanced parole, can I upgrade back to EB2 in future if need be?
Yes.
Okay. So yeah, the thing is, actually I read somewhere saying like if I use EAD in EB3, it's not easy to come back. So I just wanted to make sure.
No, the EAD, and I said this earlier, the EAD is based on the pending I-485 adjustment of status application. It is based on that. It is not based on the category. Okay. So if you have a pending adjustment application and you have an EAD, then you can do whatever you want on that. The only thing is that some people say, well, if you start working at a different job, for example, then your H-1B, using your EAD, will that eliminate your H-1B? Well, you're not complying anymore with the H-1B, so you're now relying on your EAD card. And in most of those cases, you're going to be safer changing jobs to similar job only after your 485 is pending for 180 days, because then the provisions of 204J come into play, which allows you to move to another job if you want.
Thanks, Brent. The next caller, Siva, number ending 3082, number ending 3082. You are on the air. Please go ahead.
Hi, thanks for your awesome presentation so far. It's really appreciated. So this is Siva here. So I have a couple of questions. So the first one, as you know, a couple of people asked, I'm on the same boat, like I'm on EB2 2012 date, February. So if I go and downgrade to EB3, okay, So my daughter is on 18, so she'll be turning 21 in 3 years. So if I go and file 485 for her, I'll be getting EAD in 6 months to 1 year down the line, right? So in that case, 485 EAD, if she get it, she can use that for the college admission, right?
Oh, well, that's going to just depend on the colleges and things. And some in order to show, well, that's beyond my ability to answer, because every college has, you're talking about like resident tuition or something. Every college has their own, every state has their own, rules about that.
Okay, and to follow up question, Brent, if they get an EAD, can they use that EAD to work? People who are like over 13 or 14 years?
Yes, absolutely. They can work because they're authorized. They have an EAD.
Okay, so institution, again, as Brent said, that depends on state to state. You have to contact, the university, and that's the best thing. A lot of states have consider even H4 and H1Bs as residents, but few states doesn't, right? So that's again, goes by state to state. Okay, the next caller, the number ending 8566, number ending 8566.
Hey, thank you so much for taking my call. And this is Rakesh. I have a situation where my priority date is 2013 Jan, and my employer said they won't be downgrading it through my employment. And they even said you can go ahead with my own attorney. The first thing is, am I allowed to do that if my employer is supporting it? And the second question is, let's say down the line, if the EB2 priority date is current and still my employer is not willing to file it, can I sue them? That's the second question.
Okay, so that's a really interesting question. So your employer right now is not willing to file the EB3 downgrade, correct?
Yes, that's true.
Okay, and is that because of money, or they want to just
yes, because of the budget? They said what they said is this fiscal year they don't have budget.
Okay, well, so regarding, so the I-140 is an employer's petition. It is within their right to file it or not file it. They're not required to do anything in that regard. However, if it's a question of money, then the question is, can someone else pay for it? For example, you. The Department of Labor has taken the position that the PERM and the H-1Bs, and because they have labor certifications and LCAs attached to them, you cannot pay those fees by the employee. And then there's the $1,500 training fee for the H-1B that cannot be paid by the employee by law. But there's no rules with regard to who can pay for an I-140, including the filing fee and the legal fees. There's no rule regarding that. So legally speaking, there should be nothing wrong with an employee paying for that I-140 if the employer is just solely interested in saving money and they just don't want to pay for it. If they're still willing, though, to petition for you, meaning they are going to provide the support behind the petition, the signatures required and the intent required behind it, that's perfectly acceptable for you to pay for that.
Okay. So you mean to say I can go with my own attorney rather than going with my employer's attorney? Because
that's a different issue, because the employer has the right to have, whatever attorney they want to use for their I-140, because it's their petition. If they agree to use your attorney because you're paying for the attorney and they agree to that, then that's fine. But you can't force them to do it. You cannot force them to file a petition for you.
Okay. So, and the second question was, if I'm sorry, I'm taking a little more while. But the second question was, let's say, even if the EB2 priority date is current and my employer is not willing to file my green card 485, can I take an action on them?
Oh,
You said
okay.
yes
So your
or no.
green card, your 485 application is your application. You can file it if you want. The only problem is you need to have them sign the I-485J supplement confirming your job. So if you give them the 485J and they confirm, yes, we still are offering this person the position, then you can file your own 485 all on your own. You don't have to go through their attorneys. You don't have to do anything like that. So it's your application. You're the one who signs it. You're the one who files it. Oftentimes, employers, have it as part of the I-140 petition, and it's all filed together. But it really is your application.
Thanks, Brent. The next caller, Ravi, number ending 4679. Ravi, number ending 4679.
Hi, my name is Ravi. My son is 19 years old. He's on F1 visa now. Can I file adjustment of status while he's maintaining the F1 status?
I'm sorry, I didn't get your question. Can you repeat that?
He says, let me repeat. He says, his kid is 19 years old and on F1 now. Can he file adjustment of status for his kid being on F1?
Oh, from F1 to adjustment of status. Yes.
Yeah.
Yes, you can. The only issue with F1, so I'm not going to get into the very deep discussion about F1 and immigrant intent and everything. But if someone has entered F1 or changed status to F1 and it's been some time, if the person's now eligible to file adjustment of status, there isn't anything unlawful about them filing to adjust their status, even though that is a status that does not generally allow immigrant status. And the reason for that is, as long as there is no fraud involved, that the person didn't lie to get their F1, okay? As long as there's no fraud involved, then filing to adjust status from a non-immigrant category like that is fine. I have adjusted people from F1. I've adjusted people from TN. TN is a similar situation. Obviously, there's less issues involved in the case if it's an H or an L visa that allows that intent. But there's lots of, another example is R1s, which is religious workers. They're not allowed to intend to immigrate either, and they adjust status all the time. So it's not an issue. The only issue is that once you file adjustment of status, you cannot leave the country until you get the advanced parole. The only people who are allowed to leave the country before they get the advanced parole are H-1B visa holders and H-4 and L1 and L2 visa holders. That's it. Not for E2,
not F1s?
not for O1.
Not F1?
No. If you file adjustment of status on F1 and you leave the country before your adjustment of status is, before your advanced parole, you abandon your application. It's gone.
Wow, so please make a note of that, because in case someone who is on F1 visa is filing an adjustment of status, please make sure you stay in the country until you get an advanced payroll. That's an interesting answer. The next caller is Arpan, number ending 0378. Arpan, number ending 0378.
Hey guys, thanks Brent for taking the question. So I have two-part question. One is related to what you just answered a few minutes back, that 6 months time you can shift, and that time you can shift on GC. So the backdrop is my old employer is filing my green card, and I'm still going to continue with my new employer for the foreseeable future till the time, because I'm on 2012 priority date, EB2. So when I continue with my new employer and the old employer is filing, how does the 6 month rule apply to me? And
The second part of the question is, when do I have to join my old employer? Is it after I get the EAD or after I get the green card?
Okay. This is a good question, and it'll probably come up with a lot of people. Excuse me. So, and it's pretty complex. So, essentially, at the time you file your adjustment of status application, you must file. Excuse me. You must file. Usually, unless you're filing an I-140 concurrently, you don't have to. But if you're filing with an approved I-140, you have to file the I-485J supplement. It basically says, from the employer side, I'm offering this person this job, and that would be from your old employer. They are signing the I-485J. I'm offering this person a job. And on your side, you're attesting that you're willing to take that job when you get your green card. When are you going to get your green card? You don't know. It's sometime in the future. So, but you have to have the intent to join and work for that, in that job at the time you file your adjustment of status. The only time you're allowed to change your intent to do that is once the 485 is pending 180 days. Once it's pending 180 days, you're allowed to actually not just intend to move to a different job, but actually take another job. So there is a strange thing. In fact, this scenario that you're pointing out, let's say, is actually in the memo on 204J, the scenario where somebody has, let's say they're with employer A and employer B files a petition for them, and they file adjustment of status based on employer B. 180 days later, they decide they actually just want to stay with employer A. That's fine. They can adjust status, and they would never have worked for the I-140 petitioner ever again. Now, you think that sounds like kind of a tricky situation, but it's part of the law. And the only thing that I have to say about that is that the burden might be on you later to have to prove that intention. Now, by taking a job, you show through actually deeds that you are willing to take that position that's being offered to you in the I-140 if you actually work for them. But it's not actually required. What you have to have is the intent. The intent is in your mind. And then if anyone, charges you with fraud later, you will have to prove it. And so, obviously, if there's some paper trail with regard to your intent and the employer's intent to employ you, that's fine. I think when you're in this area of you're working for your new employer and your old employer is filing for you, you really have to have a bona fide intent to go back to the old employer. So you better start making plans and all of that and start having email conversations. But then after 180 days, the law makes your situation change again. So that's why it's a very complex situation. It's not easy to explain, and I hope I've done my best with that. It's tricky.
I think you did great, Brent. That was a clear and clarified explanation. The next caller is number ending 9293. Number ending 9293. We only have a few minutes, so please be fast.
Yes. So just to continue that question, how long can I delay joining? I'm in the pretty similar situation. My previous employer, they're ready to file my change of status for EB3. So my question is, how long can I delay joining them?
Well, technically, the intent has to be this, that at the time your green card is approved, you would move to them. That's the intent that you have to have. You don't have to move in 1 month or 6 months or a year. It's an undefined time that once your green card is approved, you would move to them. And now think about this. A lot of people actually get their green cards by waiting at the consulate, and then they get their green card and they come. They're not here on an H-1B or anything. They're waiting abroad. They have to intend to come and work for the employer. And there's a lot of old cases where in the days of steamships, people would get their immigrant visa and get on a ship, and it would take several months to get here. And then when they got here, the job was gone and they were put in deportation proceedings, and they said, well, that's not fair. I intended to take the job. It just didn't work out. And
the same is with the nurses of a lot of countries, right? They just come on the green card.
Right, exactly. They just come as an immigrant. And so you have to have that intent to join the employer at the time your green card is approved. And if it doesn't happen for a year or 2 years or whatever, that's totally fine. And then again, the weird thing is that if your adjustment of status is pending for 6 months or more, that intent requirement goes away. And right now, everything's pending more than 180 days now. So it's just a really strange situation, but the answer to the question is there is no time by which you have to join your employer. There's not a specific number of months. You have to just intend to join your employer when your green card's approved.
The next question is number ending 6486. Number ending 6486. Please go ahead. Be fast.
Hi, I spoke to you before. Just for my understanding, one more time. So, are you saying because I have a 17-year-old kid, you're saying that once we file 485 now along with us, switching back to F1 from when AOS is in progress, it's not a complex situation?
Oh, I didn't say that. I just said that it is, if you file, I would say if you're pending adjustment of status, that would not be approved. I mean, I think you would disclose that even though the F1 requires non-immigrant intent, you'd disclose, actually, I am a pending adjustment applicant.
But they could try, right? But there is no other option. So
you have to fully disclose it. And yes, I suppose it could be granted if the examiner thought that you had a future intent to immigrate, but maybe not the present intent. But that's strange. I think it would be a problematic situation.
But then there is no other option, so we don't have a choice here.
I know the other option is that we win our lawsuit, and I'm really hoping that we do.
Yeah, I hope so. The last caller for today, the number ending 4753, number ending 4753, please go ahead.
Yeah, hi. My daughter is aging out 21 years on 5th October 20, and her B2 is in progress. My I-140 is approved on 12th March. So whether she can be eligible for this green card or not, her like a student I-20 is also in progress, H4, B2, all are pending, not yet approved.
Whoa.
And day after tomorrow, she'll be like at 21 years.
Okay, wait. So you saying she's pending change of status to F1?
F1, B2, H4.
Yeah, F1 is in, all three are in the progress process.
So, okay, so she's already got her change of status application in?
Like they are going to, attorney is going to file it on Monday or might be today. The AOS.
Oh,
AOS.
wait, no, but her 539.
They are pending. He says they filed B2, they filed H4, they also have F1 also in
gosh, okay. All those are pending, yeah, probably biometrics.
Yeah, correct.
Them up.
Yes,
okay.
yes.
So,
so legally she can stay beyond 5th October or not in US? Like just after Sunday.
If she has a pending change of status application, she is entitled to remain while it's pending. Regarding her, what's her 21st birthday?
5th October, 3 days from now.
5th October, yeah, Sunday, day after tomorrow.
So how long was your I-140 pending? Are you downgrading now? Or?
No, it is under EB1 and it got approved on 12th March 20. I-140.
Oh, okay. So how long was the I-140 pending?
My priority date is 13 May 2019, last year.
So, I mean, how long was the I-140, so from the date of I-140 filing until the I-140 approved, how long was it, what's the time?
Almost 9 months. It was 9 months. Yeah.
Okay.
After
Now
9 or
Brent,
10 months, we got approved.
okay. So now Brent can explain it now. Yeah.
Okay,
So you have 10 more months.
Yes, you can add the 9 months to her eligibility for filing adjustment, but I don't have the priority date chart in front of me.
EB1 is current, right? Anyways, he
Well,
says EB1. EB1 is current, right?
It's
Yeah,
not,
EB1. It's EB1.
It's not current for India, I don't think, is it?
No, it is current. Yeah, it is current, Brent. I think it's September
For dates for
2020.
filing. It's current for dates for filing.
No, for dates for filing, yeah. Current for the green card is 2018. It's still June
Oh,
or January
2018.
2018.
Oh, okay, sorry. Okay, then
Yeah.
I might be wrong.
Yeah, and your priority date is, okay, so yes, you should file her adjustment of status application before her CISPA age is 21, which you still have some time.
Okay. Okay. And only question that she's on the B2 dependent visa, so that will not create any problem, right? Like she'll be not out of status after 5th October, correct?
You probably may have to withdraw one if one is
No,
approved, right?
No, and even if, well, you should file it as soon as you can. Even if technically she got denied, and let's say you get the denial letters tomorrow, and she's got her H4 only until October 5th. There's a separate provision that allows employment-based immigrants, including derivatives, to have up to 180 days of unlawful presence, unlawful status.
Okay.
Not unlawful, but unlawful status. So you could file it after, if necessary. Obviously, you want to file it as soon as possible, but gosh, with all the forms changing and all the filing fees and all the mess, it's just, and it's a lot of application, it's hard to put an application together. So anyway, you should file if she's current, if your whole family is current now, and it's just a question of she's got some pending applications out there, file your adjustment of status, get it filed.
Okay.
And she will lock her age if she will get her age locked if before her CISPA age 21, which is 9 months from now, before her CISPA age 21, if the final action date comes current, then she will lock her age. Or if we win the lawsuit, she locks her age anyway.
Okay, that was an interesting
attorney is going to, so attorney is going to file it, might be Monday or Tuesday, so that's fine, right?
Yeah, even if it was a few months late, they're still eligible. I don't encourage that, but
Thank you.
still eligible.
Thank you.
Okay,
Thanks a lot.
it's an interesting question to end, end the session. Again, thanks everyone. Thanks for all the calls. It has been a great night. And thank you, Brent. Thank you, Brent, for your patience, for all the time, taking time to answer questions. We really appreciate what you have, for your presence, for what you've been doing. And let's hope, we all pray that you win the lawsuit, and, that should help a lot of people. And so people should remember you as being an advocate for. I know that's really that's not a small thing. We ourselves had many callers today where kids are aging out in few months. So there could be hundreds of thousands of people. They will be indebted to you if this happens. And again, Brent, very, very thanks for all the time. And I know it's been a long day for you. Thanks again. Have a great day.
Yes, thank you for organizing this.
Thank you, Ranjit.
Thanks. Bye-bye.
Bye.